The United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, we will begin argument, and please be seated. Begin argument in number 2359 Alexander versus Carrington Mortgage Services. And Mr. Zavary, we'd be pleased to hear from you.
Thank you, Your Honor. May it please the court. My name is Hassan Zavari, and I am the attorney for the petitioners. It is an honor to be here today. This is my first in-court appearance since March of 2020, and it is great to be back, and I appreciate the court opening it up for us today. So, Your Honors, this is one of dozens of cases across the country challenging what are called pay-to-pay fees, which are fees assessed by mortgage servicers that are not included in the original mortgages and are charged for borrowers when they wish to pay their mortgages online. In this case, there's a $5 fee. In those cases, and in this case in particular, the mortgage servicer only pays pennies to process these fees online. On the other hand, they charge the borrowers $5 in this particular case and have generated hundreds of thousands, and in this case, we allege millions of dollars in profits based on charges that were not in the original debt.
Mr. Zavari, you mentioned that the lender incurs just pennies in charges. Is that actually in the record? Do we have evidence of the actual costs that are incurred by the lenders?
Yes, Your Honor. That is at Joint Appendix 7 to 8 at page 3 of our amended complaint.
Is that, I mean, you haven't alleged that any kind of a claim with respect to the disparity in the cost versus the revenue generated, right? It's just a broad attack on the legitimacy of the fee based on the statute. Is that right?
Below, there was a allegation, it was part of the Maryland Consumer Protection Act claim that this disparity was unfair and deceptive, but really you're right that the gist of the case just goes to whether they can charge these fees in the first instance. And I would say
you're limiting your appeal to count one?
That's right, Your Honor. Count one, which includes causes of action under the Maryland Consumer Debt Collection Act and the Maryland Consumer Protection Act. So, and these particular fees have been condemned by the CFPB, the agency that regulates the FDCPA, and also by a bipartisan group of 31 state attorneys general, including the Attorney General of Maryland, who condemned these fees as unlawful and illegal.
Counsel, does it make a difference that someone can avoid the fee by electing to electing to make payment by mail? Does that make a difference in your view in terms of the statute?
In our view, Your Honor, it does not make a difference because the FDCPA, which is incorporated into the Maryland the Debt Protection Act, specifically was directed at preventing debt collectors from tacking on such fees. The whole purpose of it was to allow, although creditors themselves under the Fair Debt Collection Practices Act could add these fees when they're engaging in collection, the Congress was particularly concerned about debt collectors and whether or not they in fact could add those charges.
No, but all I'm asking is, does it make a difference in terms of the statute that someone doesn't have to pay the fee if they don't elect to?
No, Your Honor, it does not. And this goes specifically to the provision of the Fair Debt Collection Practices Act that was incorporated into the Maryland law. Because what that statute says, and again, this is consistent with what the CFPB and the Maryland Attorney General have said, is that if that fee is included in the underlying agreement that creates the debt, if it's included there, it's okay to charge it. But what you cannot do is to charge it, is to allow the charge to be agreed to or included in a secondary agreement with the actual debt collector. And here, in this case, that is Carrington.
So can I ask, why the distinction? I mean, and in this case in particular, since you're dealing with the original loan servicer, why does it matter? Why would Congress or any state legislature be concerned about saying, on the one hand, it's okay to have this as part of the original agreement. There's nothing unconscionable or unfair or inequitable about that. But on the other hand, it's not okay to later negotiate for a fee.
Well, that's right, because when you're entering into a mortgage, you get to pick your mortgager. You get to choose the agreement that you enter into when you get a mortgage. When your loan is assigned, you have no choice in who the mortgage servicer is, who the debt collector is. So the FDCPA was inherently concerned about what happens when the debt is assigned to a debt collector. And it's been specifically included to include mortgage servicers in this context. So,
excuse me, Judge Diaz, did you have something further?
No, go ahead.
I was just going to ask, is this, in your view, a negotiated amendment to the original mortgage agreement? Because the individual on whom the fee is imposed would have to assent. Does that make it a negotiated fee?
It is negotiated, but not negotiated with the lender and it is not part of the original, because the FDCPA speaks to the original agreement that created the debt, and it is not an amendment to that. It is a separate standalone agreement with another party.
It's negotiated with the servicer.
Exactly.
What you're saying?
Exactly, Your Honor.
And not with the lender.
Yeah, and I should say,
most of the authorities that our friend Judge Bennett relied on were other cases in the Maryland District Court, federal cases. Is there any authority by the Maryland High Court?
Yes, Your Honor. So we brought to the court's attention two recent cases, the Chavez 2 case and the Kemp 2 case. And both of these
really on point. You were asking for a certification, is what I'm getting at, to the Maryland High Court.
We did ask for a certification originally,
but you were asking for a certification of multiple issues. At that time, had you boiled it down to count one?
It was, Your Honor.
It only has to count one.
That's right. And what I would say about these two new decisions, the Chavez decision and the Kemp decision, they
control here?
Well, in one respect, Your Honor, they don't control with respect to the substantive provision that was imported from the FDCPA.
So they don't control here?
Well, they control on another issue, Your Honor, which is that the district court in Carrington are arguing that when the FDCPA, when the Maryland legislature in 2018 added provisions that said that the FDCPA provision applied here, that the violation of the provision that we are talking about, 1692F, is a violation of the Maryland law. What Carrington and what the district court argued and held was that it also imported over the definitions from the FDCPA, because the FDCPA was very clear in that it did not want to govern the conduct of loan servicers except under very narrow circumstances when the loan was transferred in default. We did allege that it was in default, but really the issue here and what we think is most important.
Does the Maryland statute say anything about being in default?
No, it absolutely does not.
The relevant provision of the Maryland statute.
So what?
With respect to count one.
That's right.
It had anything to do with being in default.
That's exactly right, Your Honor. And I think it does not say anything about default. In fact, the big distinction.
You're talking there about, let's see, 14201B.
Yes, Your Honor, section 14202 governs collectors, and the FDCPA specifically.
But 14201B defines a collector.
That's right, and it's any person collecting on a debt arising out of a consumer transaction.
That's what I was trying to get you to focus.
Right.
That's the statutory provision that you're dealing with.
It is, Your Honor, and Chavez specifically held.
And is there any controlling Maryland law
Yes,
from
Your
the
Honor.
Maryland High Court dealing with that?
Yes, the Chavez 2 case, Your Honor, which specifically says
That's the recent case?
that is the
So
reason.
you don't need any certification?
Well, I don't think that we do, Your Honor, because I think Chavez 2 makes it clear that the Maryland statute is specifically aimed at protecting consumers from anyone engaging in a debt collector. And it says creditors. It specifically says creditors. This includes creditors. It has nothing to do with whether you're a creditor or a debt collector.
As I understand it, you think that there's no exception to the statute for someone who services a debt as opposed to someone who actually goes out and collects it. I mean, I guess that was the import of the Chavez decision. But as I understood your position, you hung your hat on the words creating the debt in the Maryland and in the federal statute. And that if those words creating the debt would prohibit a later modification, even if the later modification were involved a voluntary payment, the key point in time is when the debt was created by the original mortgage document. That's part of your textual argument, is it not?
Yes, it is, Your Honor.
And then the other part that I was saying, you've engaged with your opponent in this debate over what the phrase permitted by law means. And permitted could be read to require affirmative permission, or it could be read to require something that was just not prohibited. I mean, that's where the rubber hits the road in terms of this crucial phrase, permitted by law. So why don't you give us your best argument for the position that permitted by law requires some sort of express authorization, that it requires sort of a permission slip?
Absolutely, Your Honor. That is exactly where the rubber hits the road. And the argument, I think, is best summed up by the CFPB, which we submitted their amicus brief. But it's a plain statutory interpretation argument. And there are some contexts when permit can mean not disallowed. But in this context, where you have a prohibition against the collection of debt, and then two exceptions, right? The exception is when it's expressly created by the debt or permitted by the law. If you allow it to be the debt to be collected by some other agreement, by some secondary agreement, you've basically made that first provision completely superfluous. And in interpreting statutes,
I mean, yes, that I thought that was your strongest statutory argument, because if permitted means expressly authorized, then the term expressly authorized earlier in the statute becomes completely unnecessary and superfluous.
yes, Your Honor.
That's just as a matter of the statute. Just to me, this whole thing comes down to the text. And I thought that was your strongest textual argument. But at any rate, your time has expired, and I'm going to ask my co-panelists if they have any further questions of you, because if they do, we'll wait for you to answer them. Judge Diaz, do you have any questions you wish to ask?
I do not. Thank you, Judge Wilkinson.
Judge King, do you have some questions you'd like to ask? Or
I do not. I'm fine.
All right, well then let's hear. Thank you. You've got some rebuttal time.
Thank you, Your Honor.
And let's hear from Mr. Levin.
Thank you, Your Honor. Frederick Levin, representing Appellee Carrington Mortgage Services, Inc. I wanted to just dive right into some of the questions, Judge Wilkerson, that you asked and respond to them. First, you asked, does the ability to make an agreement, does choice matter? And the answer is it matters quite a bit in this case. It matters to the threshold question of whether Carrington was engaged in debt collection at all, which is a threshold element under the Maryland Consumer
But
Debt.
doesn't the Chavez case present an obstacle for you in that regard? Because it says that the application of the statute is not dependent on the method of collection, and that would seem to include those who simply service a debt.
Well, no, I think doesn't read Chavez correctly. Chavez, the point of Chavez is it reversed a line of cases that distinguished between methods of debt collection versus the validity of the underlying debt. It did not rule at all. It didn't even address the question of whether loan servicing is always an act of engaging in debt collection. In fact, the district court here did not ruled in a manner consistent with Chavez because it recognized that loan servicing can be debt collection, engaging in debt collection, but that it wasn't here because all that happened here was that the two plaintiffs went online without any prompting from Carrington and used a payment service. There was no debt collection activity here. I don't know.
I'm wondering if you're not asking us to write in an exception to this statute. We sit in on a lot of these consumer protection cases, and I do have to say that Maryland law seems to be about the most protective of any state, and the Maryland decisions plus the statute seem to opt for a fairly broad coverage. And if we try to say, well, this is debt collection, but this is not, or whatever, I think we come close to enacting an exception for debt servicers from the statute. And I'm not sure the statute allows us to do that.
Well, Your Honor, the statute requires as a threshold element that that there be engaging in debt collection activity, right? And all we're saying is, in some instances, loan servicers engage in debt collection activity. But for example, the case that Judge Bennett cited, the court held that it did not engage in debt collection activity. So we're not asking for an exception.
What case was that? Sorry.
A case called Seghetti.
Is that a Maryland case?
It's a Maryland case. Sorry, it was a Maryland District Court case, I believe.
But that's what I was getting at earlier. It seemed like the authorities relied on were other decisions of other judges in the Maryland District Court. And the state law of Maryland that's authoritative has to be decided by the Maryland courts, but indeed the High Court of Maryland. And that's what they were, at one point, they were asking for a certification to the Maryland High Court.
But the decisions that Judge Bennett relied on were not inconsistent with Maryland.
No, but they weren't a precedent.
Correct.
They were not precedent, controlling precedent. You just said, back at one point, I think they mentioned Judge Blake of the Maryland District Court. Well, Judge Blake's a wonderful judge, but she doesn't sit on doesn't speak for the Court of Special Appeals or whatever it's called up there.
So, but the issue here is whether Judge Bennett got Maryland law correct on this point.
There's nothing in that statute that says anything about the debt being in default or anything.
No, it doesn't say
In the
that.
Maryland statute, I'm talking about the definition of a collector.
Right.
Nothing there.
What it says is that in order for there to be a liability under the statute, there must be engaging in debt collection. And here the point is where there's
But there's no exception to coverage written for debt services. And just as an intuitive matter, if somebody is a debt servicer, they're actually collecting.
right.
the fee.
But
They're making, I mean, they're
Harrington
making
is-
they're making a great deal of profit off of this, which is what debt collectors normally do. They don't engage in it just for the, just for the heck of it. They engage in it to make a significant profit, and they collect these fees and they derive a profit off the fees. And, there's nothing wrong intrinsically with that. I'm just saying I think as best I read the Maryland courts, and I think Judge King makes an important point, that the Maryland courts are critical here, and they seem to want, I don't know that I necessarily agree with them, but just as a matter of statutory interpretation, the Maryland courts have seemed to opt for fairly broad coverage. And when you look at this statute, I wonder why it's not a fairly straightforward case, because it says you can't collect any amount unless the amount is expressly authorized by the agreement. And it's not expressly authorized by the agreement. And is it otherwise permitted by law? I don't see your permission slip. And as I indicated in the previous to your good opposing counsel, if permitted means it has to be expressly authorized or whatever. If permitted means expressly authorized, then there was no need to include expressly authorized in the statute. It renders that term totally superfluous.
well, Your Honor, let me address that because I think that aspect, there's two elements of the FDCPA, or actually three elements of the FDCPA where that turns. And let's assume for purposes of argument in light of what the court is saying, that they satisfy the debt collector, the collector element of the Maryland statute. The incorporated federal law has the statute that's in question, section 8081, which is the incorporated section that they rely on, has three elements that must be satisfied. And the Maryland law very clearly says that what they punish is a violation of that statute. And to violate that statute, one must be a debt collector for purposes of federal law. It's admitted here that Carrington was not a debt collector for purposes.
But how do you deal with the Chavez case, which says that the coverage doesn't turn upon the method of collection? I mean, and
coverage. I think that the Chavez case is saying that is reversing a line of cases that focused on that. But this is not about the method of collection. This is whether there's a violation of 8081. And
well, you said it was a matter of the method of collection because you've pointed to the fact that all they are is a debt servicer who doesn't really go out and collect. And your argument with respect to coverage depends on the method of collection. And that's where I think Chavez is not helpful to you.
Our argument does not depend on a method of debt collection. Our argument depends on which is the statute that they insist is the relevant key point, is the incorporated federal statute.
But the Maryland statute defines the collector.
Yes, I am,
defines
for
it.
purposes of argument, assuming for right now that they are a collector for purposes of Maryland law. However, the Maryland law that incorporates the federal statute.
And that doesn't require the debt to be in default. So a debt servicer.
It doesn't require,
the
debt servicer for purposes of it, for purposes of this argument, I'm saying it doesn't require, just to get to the point about the federal statute, all right? It has three separate elements. The incorporated Maryland law says you have to violate that federal law, all right? To violate that federal law, you must first be a debt collector.
Doesn't the statute actually import the conduct, not the actual definitions? I mean, well, let me just finish.
Without doing
Let me finish.
Sorry, excuse me, Your Honor.
That's okay. Because it would seem odd, wouldn't it, to have this broad remedial statute and then import conduct and place a limitation that would require the importation of a federal definition of debt collector into a state statute. So how do you get to that?
First of all, I get to it from the plain language of the statute, which focuses on a violation of the statute, all right? And the legislative history of the Maryland law. To violate the statute has three elements. First, you must be a debt collector as defined by federal law. As you must then, the fee in question must also be incidental to the underlying debt. And three, it must either, it cannot fall within the exception expressly created by the debt or permitted by law. And I think Judge Bennett found that each of those elements wasn't present here. And I want to address why that's the case here. Okay, but to get to your question about the incorporation, when a legislature borrows a statute, a federal statute, to make it state law, all right, it is necessarily bringing with it the defined terms it incorporates, right? There's Fourth Circuit cases that say that, right? Because otherwise, the statute itself proves that. Why? Because the incorporated statute has three defined terms: debt collector, communication, and consumer, all of which are defined in the federal statute. And the question then is, did the legislature intend for the federal statute to have one meaning when incorporated into Maryland law and a separate meaning standing on its own? No, it was.
But collector is defined in the Maryland law.
Right, but what that statute says is collectors are subject to the federal law, and federal.
It says in this subtitle, the following words have the meanings indicated. And then B, collector with quotation around it means a person collecting or attempting to collect an alleged debt arising out of a consumer transaction. And saying about one being in default.
I'm not arguing about it being in default. I'm arguing that which was legislature.
Maryland defines it themselves.
That's right, but they also incorporated a statute that uses a specific term, which is an element of the
federal law supersedes it. Is that what you're saying? I think so.
I'm saying you have to blend the language together, because otherwise you're rewriting the federal law that was incorporated. And the way
Judge King is pointing out something that Maryland is not powerless with respect to this question, and it's not faced with an all or nothing choice that you have to incorporate every dotted I and crossed T in federal law, or you can incorporate nothing. Maryland can be judicious, and it can even be selective in what it chooses to borrow from federal law and what it doesn't. And Judge Diaz made an interesting point when he was speaking. He said, this is a remedial statute. It's a broadly remedial statute, and the purpose of it was just fairly construed, I think, to protect people in these situations, including homeowners, from being hit with little fees down the line, of which they were given no notice in the mortgage agreement. Now, if we take a broadly remedial statute and say, oh, well, there may be an exception here, and maybe this is not debt collection here, I wonder whether we're not just writing in complexity and exceptions into a statute, and there's a danger here of undercutting what I think are the statute's clear remedial aims. I mean, I don't know whether this is wise policy, because it may force companies and lenders to put in all kinds of fees up front, just as a protective measure in order to protect themselves. But whether it's good policy or not doesn't bother me. It's the statute which says that consumers, including homeowners, are to be protected against later surprises. That seems to me what the statute is getting at.
Right.
And I don't know why we can't give it a generous reading in accordance with its aims.
Well, because Your Honor, and given my time, I want to move on to address the key points at the end. I would just say that cannot do that without, and we talk about it in our brief, the legislative history, which shows a very conscious decision by the state legislature to focus on the violation of the statute, not conduct prohibited by it. But let me turn to the questions that you addressed earlier with the difference between the provision that says authorized in the agreement creating the debt and permitted by law. Our argument here is that the subsequent contract is permitted by law, and that it does not render superfluous the prior section, because a contract that is authorized in the creation of the debt, the legislature is saying is the fees authorized there are okay, notwithstanding other law, no matter what other law says here. That does not necessarily mean that subsequent agreements are barred. That's the implication. It's not. The office of that provision is in effect to provide a safe harbor at the original point of contracting. It says, and because otherwise what you're doing is rewriting that statute where it says authorized by the agreement creating the debt or permitted by law. What you're really doing is you're changing the latter.
Very often in what you term a subsequent agreement, the power dynamic has shifted somewhat, and the consumer may be over a barrel and feel that they don't have any. And here they did have a choice, but I'm just.
But not
this whole idea of subsequent agreement. I'm not sure that the subsequent agreement doesn't find a good many consumers in a difficult position. Maybe not in this case where they have to consent, but in many cases,
but
they have no choice.
That's the point here. We're talking about the facts in this case. And the facts in this case is none of the kind of coercion that you're referring to was at issue here. The district court went through, this was an actual consented to agreement where the party chose and had other options. So the concerns about oppressive conduct just are not present here. They're not even argued, right? There was no notice of default, no calls, no threats, no anything. And the point is, and in this instance, there is absolutely no indication that these consumers were in default or were being pressed to pay. This was how they paid day in, month out. That's why it's simply ordinary course servicing, the collection of payments when they're due.
Well, can we go consumer by consumer and ask, whether there was coercion or whether the mortgage was in default or whether they knew of this previously or what have you. I mean, I don't think.
Yes, Your Honor, that.
Fact by fact by fact.
Yes, Your Honor. I think that's why there's the exception for permitted by law, which encompasses contract. That is where there's a fact pattern like the convenience fee fact pattern, where it is absolutely coercion free. There's no allegation of that. But where there is those things you're concerned about, the ordinary rules of contract law apply. Unconscionability applies. Fraud in the inducement applies. All of the defense.
It doesn't say anything about, the statute doesn't say anything about later coercive add-ons. It's almost, it says, no, you cannot impose these additional fees. It doesn't make it dependent on this fact or that fact or whatever.
What it makes it dependent upon is whether it's permitted by law. And
so where's your permission slip?
the permission is in the law of the state, which authorizes.
You could have agreed to it, or this could have been agreed in the mortgage. But they said if you mail in your payment, it's going to be this amount. And if you pay it online, it's going to be a different amount that's $5 more. That'd be it'd be in good shape.
Well, these mortgages were written in 2005 and 2009. And the point is that what the effect of this is, and I don't think it was an intended effect, was to prevent a company like Carrington from authorizing a new service that wasn't contemplated at the time, wasn't subject to the agreement. There was an agreed upon method of payment. Now a better way comes along, right? And what the implication here is that Carrington must now offer that new and better way for free or not at all right? And I don't think the law requires that because it gives the out of permitted by law. And permitted by law is inclusive of a valid contract, right? And by allowing a valid contract does not limit or render superfluous the earlier mention of contract expressly created in the debt. And we know that because in order to get the meaning that it does, you have to change the meaning of the subsequent clause permitted by law, because what you're really saying, the permission slip, has to be by statute. And
all
if
right,
that's
but you, again, your view of permitted by law, it runs into the Second Circuit's Tuttle case, which says if state law neither affirmatively permits or expressly prohibits charges, a service charge can be imposed only if the customer expressly agrees to it in the contract. So you've got that Tuttle case that is a bar there, and you've also got the federal regulation, 53 federal regulation. There's so many numbers I can't pronounce them when I get to the Federal Register. But the FTC staff commentary on the FDCPA says that the charge needs to be expressly permitted by state law, expressly permitted, not just silence or allowed. I mean, they're just things that are accumulating against your position.
I recognize that, but I would say at the end of the day, it's the statute that counts. And what the commentary does is change the words of the statute. It takes that express that modifies the original contract provision and moves it over to after the or express.
All right. Well, all I'm saying is the commentary is not helpful.
I agree, but when the language is plain, the commentary is irrelevant. And the Tuttle case that you, excuse me, Your Honor.
You were relying on legislative history. So, I mean.
For a different point, Your Honor, for the point where relating to Maryland law, where there's a genuine ambiguity in the statute, right? But where the statutory language is plain, and you'd have to effectively rewrite the clause after or permitted, right? To say or permitted by statute, right? And permission has to be, and law has to mean something other than
All right.
just statutory law.
We've let you go for 5 extra minutes, counsel, because we're very interested in your case, and we're very happy to hear your argument. But at this point, I'm going to ask my friends on the panel if they have some further questions of you, Judge King.
I do not. Thank you, sir.
Judge
I don't-
Diaz.
I don't either. Thank you.
Thank you, Your Honor.
Well, we thank you, Mr. Levin. All right, Mr. Zavory, you have some rebuttal time, sir.
Thank you, Your Honors. So I want to start by discussing the argument that my friend made that the Maryland statute, when it incorporated and used the word debt collector, that it was inherently engrafting in this definition from the FDCPA. And I think the most important, and if we're going to make an eerie prediction on what the Maryland the Court of Appeals of Maryland would do, I think the best guidance is in the Nation Star versus Kemp case, where there was an amendment to the Maryland's usury law. And there was an argument about what the amendment meant and whether it's substantively changed the provision of the law. The very beginning of that statute says, a clever man once said, a cauliflower is nothing more than a cabbage with a college education. That clever man was Mark Twain. And the decision then goes on to say that a new law that is nothing more than the old law is nothing more than an old law with a college education. And what I would say here, Your Honor, and Your Honors, and why that applies here is, and then the decision goes on to say that you can't have interpret the new provisions in a way that results in an absurd result, right? And that you have to interpret it consistent with the original provision. You're still dealing with a cabbage, although now it's got a college education. And here it would be absolutely absurd and would lead to absurd results to have this definition of debt collector, and where the Maryland Court of Appeals has said that that applies to servicers and it applies to creditors, right? It applies to both, unlike the FDCPA, that in some provisions you're going to apply a narrower definition, and in some other provisions you're going to apply the broader provision that the Maryland legislature actually adopted.
But I understand your colleague's argument to be that where the statute actually talks about incorporating violations of federal law into the state statute, that you can't have it. It's not a halfway proposition. The violations include all of the elements of a violation of federal law, including the definition of a debt collector for purposes of that particular subsection. I suppose the state legislature, if it had been more careful, could have simply described the conduct that it intended to incorporate under federal law, but it didn't. It said a violation, certain conduct, which is a violation of federal law, is incorporated here. And your colleague is saying you got to take the whole thing, including the more narrower definition of what a debt collector is.
Well, perhaps, Your Honor, if that statute didn't have its own definition that governed it, but it has its own definition. And to reach the result that my friend advocates for, you would have to basically disregard the definitions and the Maryland Court of the Court of Appeals of Maryland's pronouncements on what those definitions mean, and years of law applying that statute to both creditors and to debt collectors. And there's simply no basis for doing that. And as the Nation Star versus Kemp case determined, that would lead to absurd results. It would be illogical. And it would counter, as Judge Wilkinson said, a broad remedial statute and the purposes of the broad remedial statute. And in particular, the Kemp court also said a particular section of a statute must be construed in a manner consistent with the larger statute's object and scope. And the object and scope of the Maryland Debt Collection Practices Act was specifically to govern creditors and debt collectors. And it would, to accept my friend's interpretation, you would be engaging in and applying a definition that is contrary to the larger statute's object and scope. So that's what I would say with respect to that argument. The other argument that my friend began with was that what the district court was that the threshold question is whether or not they were engaged in debt collection. And Judge Wilkinson said, well, that goes really to the methods question. And my friend said, no, it does not. Well, I will point out that in their opposition brief at document 29, page 29, Carrington specifically argued that what the district court was doing was an analysis of the methods versus the amount. Quote, the district court recognized that the MCDCA does not make the charging of unauthorized fees separate from collection of a debt actionable on its own, and called out plaintiff's theory of the case, challenging Carrington's authority to charge the convenience fees for what it is, an impermissible attack on the validity of the fees, as opposed to a challenge of the method of collection. Well, we now know that that is a distinction without meaning, according to the Court of Appeals of Maryland. And so the idea that somehow the question of whether they were engaging in debt collection governs is based on this distinction between methods and amounts, which we now know no longer holds. And so under Maryland law controlling here, we don't have to make an eerie prediction. We know exactly what the Court of Appeals of Maryland would say. This
You know
distinction,
that the Maryland Court of Appeals is not the High Court of Maryland?
I'm sorry, it's the Court of Appeals of Maryland, which is the High Court of Maryland.
All right.
So I misspoke. It is the Court of Appeals. The Court of Special Appeals issued one of the decisions, but the Chavez and Kemp case were both decisions of the highest court of Maryland, which is the Court of Appeals of Maryland, Your Honor.
Can I ask a question about this section 808 provision that talks about expressly authorized by the agreement, creating the debt or permitted by law? Is it your position that expressly authorized modifies both the agreement and permitted by law?
No, it is not, Your Honor. It is our argument that by using the expressly permitted in the first clause, that if you take that out, that if you allow something that's not expressly permitted in the second clause, that it would render that meaningless, that applying a permissive standard as opposed to a mandatory standard on the permitted by law provision, that it would render the first piece superfluous.
And why is that?
Because by saying that it needs to be expressly authorized in the governing contract, if you take that away, then it could mean that and I'm sorry, I misspoke. If that provision governs and has the force that it's intended to have, then it cannot also be that permitting by law by some non-express provision of law could somehow control. It would just render that first piece just meaningless.
Well, I mean, the expressly authorized by the agreement, the initial contract is a contract signed by the parties, right? The mortgage document. The subsequent agreement is also, if you have an agreement, is also a document signed and authorized by both parties. So what's the difference?
Because it's not actually signed by both parties. It's signed by a stranger to the original debt. And that's the point of expressly authorized by the original agreement. The point is to make the emphasis on the original agreement. That's the whole governing principle behind this provision of the FDCPA. It's the notion that at that time, they were not concerned about what creditors were going to do. They thought, well, creditors have an existing business relationship with the borrowers, but these debt collectors do not. And the people don't get to choose their debt collectors. So if they agree with their lender, and it's expressly included, that's fine. But you can't have a debt collector starting to impose additional fees on top of that. That's a separate agreement that the borrower has no choice in. And I see that my time is up, but if there are no further questions, I thank your court for your attention.
Any further questions? Judge King, do you have any further questions?
I do not. Thank you, sir.
Judge Diaz, do you have further questions?
No, thank you very much.
Okay. All right, I'd like to thank both of you. We very much appreciate your arguments, and for reasons that we all understand, we can't come down and shake hands and the like, but that doesn't lessen our appreciation for two able arguments one little bit. So thank you very much, and have a pleasant afternoon, and we'll we will head into our next case.
Thank you, Your Honor.
So please move your.
Howard Anderson, appointed counsel for appellant Robert Black. May it please the court. As we've laid out in the brief, this is a somewhat procedurally complicated case that we sort of have several buckets of things to talk about. We have some some special conditions of supervised release that I have challenged. But before we even sort of get to those sort of constitutional issues, there's an issue about actually what was the sentence and then how was the sentence imposed. As you see, the judge, I guess, was trying to help out defense counsel to reflect a ruling that postdated the original sentencing, but before the time to appeal had expired. And so he brought counsel in and said that he was going to do a resentencing. And my position, as I've laid out in the brief, is if we're actually going to do a resentencing, that the law requires it to be a real resentencing and not a fake resentencing. This is not North Korea or Cuba. We don't do shadow court proceedings. And I would submit that if our standard here was it a real sentencing procedure, it did not comply with both statutory law and case law about what the district court must do. As I've laid out in the briefs under 3553C, Congress requires the district judge to state, quote, in open court, close quote, its reasons for the sentence. Here, not only did the court engage in no analysis, but several days after the judge issued his, reissued his sentence, we then have a guidelines order that further explains the guidelines issue. And I would say, Judge, that that's just not a real resentencing. Did the
guidelines go from initially 24? Well, what was the criminal history or whatever it was?
Oh, right. So he was a category 3, and then the issue was going to be whether the base offense level was a 14, a 24.
Yeah, base offense level I'm talking about. Yeah. It started out at 24, and then after the sentencing, the judge said, well, it really should be 14. And that's when he called him back.
Correct.
And then what you gave was not a resentencing, but to call it a resentencing by the government, but it was on the basis of the 14. And then it was after that changed back to 24. Is that right?
Correct, Judge. So the 24 is going to apply.
24 to 14 to 24.
Right, and the 24 is predicated on being a minor.
Hearing after that, there's 3 sentencing hearings.
For Mr. Black, there were 2 sentencing hearings. There was another
2 sentencing hearings, and then there was a 2255.
Correct.
And you weren't in any of those.
Correct.
But the lawyer in the 2255 was different than the lawyer in the sentencing and resentencing.
Correct. It was Ms. Sarchi. Yes, Judge.
And was it stipulated that the lawyer in the sentencing and resentencing were ineffective in violation of the Sixth Amendment?
Judge, one of the issues in the 2255 was that trial counsel didn't file a notice of appeal. And as I understand the record.
That's what I'm getting at.
Right. And as I understand the record.
They had an obligation to file a notice of appeal and didn't do it. But that was with a different lawyer. It was one lawyer handling the 2255 and one lawyer handling the criminal case. So in the 2255, they granted relief. The judge granted relief. Same judge.
Yes.
Judge Norton, good friend of ours. He granted relief and said, we got to resentence him again. That was the third sentencing I'm talking about. We got to resentence him again so the appeal time starts to run again to give him a right of appeal. The judge is trying to help you out or your client out, right?
Yes,
and
Judge.
he granted that relief, resentenced him the third time, started the appeal time running, and directed the clerk to file a notice of appeal on behalf of Mr. Black, who's now your client.
Yes, Your Honor.
In this appeal.
Yes, Your Honor.
And that's how you get up here. Then you got appointed by
The Fourth Circuit, Judge.
you got appointed by us.
Yes, sir.
All right. Oh, good to have you here.
Uh,
Did any of the procedural history that I recited wrong?
I believe that is correct, and the government, I guess, consented to the out-of-time appeal, and so under the prevailing case law, the judge has to impose the same sentence to just restart the clock. But that was as I understand, the government was not conceding.
Well,
that
there was no out-of-time appeal.
Well,
The appeal was in time. It was the one filed by the clerk on behalf of your client.
to moot
That's
the
the
issue,
only notice of appeal.
to moot the issue of trial counsel's ineffectiveness, the government consented to having a new judgment entered.
Well,
Yeah.
everybody agreed they had to do it. That a notice of appeal should have been filed, and no notice of appeal was filed, and the time was expired. I'm going to fix it right now.
Yes, Judge.
And that lawyer was discharged.
Yes, Judge.
And what about the lawyer in the 2255?
The 2255 was relieved, I think, at the in the judge's order imposing the third sentence.
There's no 2255 pending.
There is, I think, an issue. There might be an issue that's been put on hold pending the outcome about this. I think it has to do with whether
There's still the 2255 is still pending.
I believe, Judge, I'm going to have to check the record, but I believe that his order said that there was one issue that was going to be taken under advisement.
Heard of anything
Can I
like
just say, and to try to cut through the procedural thicket here, is there any confusion? These two sentencing and the resentencing were 2 weeks apart. And it seemed to me that they essentially say the resentencing reached the same, as I understand it, reached the same result as the original sentencing, which was just 2 weeks earlier. And was there the slightest bit of confusion on the part of petitioner as to what the sentence was? Because it had been announced orally in accordance with Rogers 2 weeks earlier. As far as I'm able to tell, it was within a guidelines. It was within a guideline sentence, and the district judge in the initial sentencing went through the 3553A factors and explained those, and then had the resentencing in order to give you a chance to appeal. That was a nice thing for the district judge to do, and I wonder if it isn't a case of no good deed goes unpunished. But where is the injustice here? Where is the confusion here? I don't see it.
Judge, I would agree that Mr. Black heard the original sentence, and so he would have, if we're allowed to incorporate by reference, he heard all the judge's words. But the issue on the second sentencing is that the judge gave a within guideline sentence if Mr. Black actually trafficked multiple victims, and one of those victims was a minor.
Mr. Anderson, I'm sorry to interrupt you, and because I think the question I have is related to Judge Wilkinson's question about the injustice, if any, about this sentence. But you made an argument in your brief that even the initial sentence was flawed because the court didn't take into account any of the various mitigating factors that had been set out at great length in a sentencing memo that your predecessor counsel had included in the record. And this wasn't a run-of-the-mill sort of colloquy, well, he's had a string of bad luck. He went into great detail about this individual's background, childhood, deprivations, history of prostitution in the family, drug abuse, et cetera, abusive father. It went on for a couple of pages. There was absolutely no mention of any of that by the district court judge in his initial decision to sentence. And that concerns me because he just jumped right into the aggravating circumstances of the offense. So why isn't that sufficient to warrant sending this case back? Because, I mean, and maybe it may have been that the defense counsel didn't highlight it sufficiently enough in the oral presentation at the argument, but this strikes me as something more than the routine bit of mitigation evidence that you see in a proceeding that might warrant, not much attention. But I don't want to be overly critical of the district court judge because he was trying to bend over backward to protect the right of appeal. But lost in all of this was the fact that this was a fairly substantial mitigation case. What about that?
Judge, I would agree with you that this case can be sent back for several reasons. Either the resentencing wasn't really a resentencing, or there was a problem with the explanation in the first sentencing, or we've got these plain error on these supervised release conditions. So those are the three ways that it can go back. And I would agree that sort of however we get there, it just needs to go back to sort of fix these problems. But I'm particularly concerned about the lack of mitigation analysis, because then when Mr. Black comes back in, at least he tried to address what he thought was one of the judge's concerns. And, if it's a real resentencing, the judge didn't even acknowledge that and say, well, I find you to be insincere, or you didn't correct what my problem was. And so again, whether it was kabuki theater or not, I just don't know. But this is not the ordinary way that sentencings are done in federal court. If I could, I'd like to briefly touch on the conditions of supervised release. The one that's sort of most troubling is the one that prohibits Mr. Black from having any unsupervised contact with minors. As I lay out, that's problematic in part because he has minor children, and we can't delegate to a probation officer the ability to effectively terminate someone's parental rights. Like that's a condition for the judge. And so I would ask the government if they can point to anything in the record that would give the probation officer any guidance whatsoever about how to decide which types of children he can and can't have contact with. And if there's no...
If KS was a minor, which it seems she is, it seemed to me that the special condition number 7 was designed to prevent a recurrence from that. And the case law, you made the point, you make the point that no, there's no mens rea here. But the case law says it's pretty clear that chance encounters and chance meetings and inadvertent contact would not be a supervised release violation. And in any event, finding a supervised release violation would have to go back up to the sentencing judge to find that. But as I understand from the case law, first of all, the unsupervised conduct with children would seem to be related not only to a 3553A factor, but also related to the nature of the offense here, which involved a minor. And that the case law is pretty clear that if you have incidental contact with or inadvertent contact with a minor, that's not a supervised release violation. Nobody can help that. These supervised release conditions, a district court has to rely on some form of delegation. A district court cannot, sort of oversee every little detail in connection with these special conditions. He has to rely on the probation officer to do these kind of things. And I don't see the problem with that special condition number 7.
Well, Judge,
Problem.
one problem is that, as you mentioned, that seems in part to be driven by the notion that KS was a minor. But in Joint Appendix 237, one of the objections that trial counsel made was that KS was not a minor. And so that was just one of the things that the district judge needed to resolve. And if it turns out that there were no minors involved in what Mr. Black was doing, then that condition may or may not be appropriate
That was
substantively.
never resolved?
Correct, Judge.
Did the probation officer not say she was a minor?
The district judge, I did not resolve it.
No, but he adopted the PSR.
Correct. So in the first sentencing, prior to the first sentencing, trial counsel made several objections to the PSR, including the number of victims and whether any of them were minors. At the first sentencing, trial counsel withdraws the objections. Then the judge issues his first order on the guidelines, and we come back in for the second resentencing. And then trial counsel says, Judge, if I would have known what you would have said in your order, I wouldn't have withdrawn my objections. I'd like to reinstate my objections, including that KS is not actually a minor.
Did he say he would like to reinstate his objections, or that he did reinstate his objections?
That trial counsel said that she was reviving her objections and she was going to stand on her papers. And there are several pages of argument about why KS wasn't a minor. And that's a factual issue that the judge needed to resolve. And that would also—
Didn't the judge adopt the PSR?
In the first hearing, yes, when there were no objections. Then we get to the resentencing. I have objections.
And he didn't resolve it.
Correct, Judge. At the second—
After it was resurrected.
Correct. And so that would drive—
Counsel, with respect to the mitigation case that my colleague has mentioned, that was in the PSR. What mention of the mitigation case was made during the in-court sentencing proceeding? I realize there was a lot in the PSR, but what mention of the mitigation case was made in the sentencing hearing?
Well, Judge, first, I think it's fair for a defense counsel to assume that a trial judge has read the pretrial submissions. And trial counsel made— I would—
I understand, unless, it's also incumbent, I think, upon counsel certainly to object to any enhancements or whatever in the PSR. Now, this doesn't concern an enhancement. This concerns mitigation. And the question I have is, obviously, there's a duty on counsel to object to the enhancements in the PSR. But what I'm interested in is what duty you think there is on the part of the attorney to reinforce what was said in the PSR and bring that to the attention of the district judge. And if the district judge hasn't explained it to your satisfaction or dealt with it to your satisfaction, isn't there some obligation on the part of counsel not to just sit there doing the sentencing hearing, but to make apparent orally to the district judge, not just to rely on a PSR report? Because you can say, well, we assume the familiarity, but it's a lot more effective to actually make a point of it in the actual sentencing proceeding. And what I'm interested in hearing is what during the sentencing hearing, what use or mention was made of the mitigation case.
Judge, that's going to be in appendix starting at page 170. And trial counsel, she makes a specific request for a below guideline sentence. And she starts by saying the reason for the request is as stated in our memorandum. And then from page 170 to 180, she summarizes sort of at high level many of the things that are in that memorandum there. But again, she explicitly alerts the judge that she filed a memorandum, and that's a basis for it. But again, she goes orally over 170 to here to 179, so 9 pages of transcript summarizing that sort of mitigation case. And so I would say that was enough.
Okay, you've got some rebuttal time, and we've given you a little extra time. So I'm going to ask Judge Diaz and Judge King if they have any further questions from you. Otherwise, we'll wait and we'll hear from you in rebuttal.
Thank you, Judge.
Judge
I'm
King.
fine. I'm satisfied.
I am too. Thank you.
Okay. Thank you, Mr. Anderson. And we will now hear from Mr. DeHole.
Thank you, Your Honors. May it please the court. I'm Andrew DeHall, and I represent the United States in this appeal. Before I get into addressing the issues we've briefed, Judge King, I did want to answer your question about the posture of the 2255. There are 2 claims of direct error by the district court still pending that have been stayed, and they actually dovetail into this appeal. They are, was the explanation sufficient, and did the district court make a mistake by not addressing the second apology? Ms. Sargi, the 2255 lawyer, was appointed by Judge Norton specifically for a hearing on whether trial counsel failed to file a notice of appeal and was deficient in that regard. Once that issue was resolved, the purpose of her appointment was terminated. So that's the posture of that, of the 2255 at this point.
So these are something other than ineffective assistance claims.
Correct. That's correct, Your Honor.
And so the relief that was granted was based on the ineffective assistance claim.
Correct. We consented to relief being
You say
raised.
you consented, so there had been an agreement or that counsel was ineffective and failed to file a notice of appeal, and one was filed. Had a third resentencing, and there was one filed.
Correct.
A notice of appeal was filed by the clerk on behalf of.
That's correct.
Yeah, on behalf of Mr. Black, who's now the client.
Right. I believe he's on his third attorney.
Mr. Anderson.
Yeah, we have Mr. Anderson. So I just wanted to clear
There's
that up.
something else pending, and that's fine. You go ahead, Ed.
Yes, sir. So we believe that the proceedings below did ultimately produce a sound within guideline sentence, and we're asking that it be affirmed.
But the argument that's being made here was that there was an argument for a downward variance or a downward departure, and what is your response to the concern that the district judge did not address the mitigation case and the plea that was made for a downward variance?
So a couple points in response to that, Your Honor. First, the issue about his upbringing was tied into it. The argument flowed was, I had a horrible upbringing that led me to use drugs, which led me to get into this kind of conduct. So it was all intertwined. And that central thesis of the mitigation argument was rejected by the district judge when he said, I don't buy that. So my first point in response to that is, while there's no separate discussion of the upbringing, apart from saying I don't buy that, that does seem to be included by the district judge saying he did not buy that overarching mitigation argument.
But that, that addresses half of the sort of the basis for mitigation. He didn't buy the reason for the conduct that the defendant engaged in was the result of his drug abuse. But then there's a separate just case of the defendant having suffered, as alleged in the papers, this sort of very difficult upbringing, and it went into pretty good detail about that. That in and of itself is, in my view, evidence that a district court needs to consider in deciding what should be the appropriate sentence in this case. And I think our cases are pretty clear that a district court has to engage with that argument. I hear you saying that at best he engaged in it indirectly by torpedoing the explanation given for the conduct, but that's only half of the argument, isn't it?
Well, I think the way it was presented, they were intertwined, but I understand Your Honor's concern that they could be viewed as separate. And I mean, I would have to candid in admitting there's no separate on the record discussion of that upbringing. So I mean, I can't argue with that or quarrel with that. However, I would also point out, I believe it's pages maybe 178 through 80 of the JA, where, as my friend on the other side was referring to the mitigation argument, trial counsel says, well, I guess it's not trial counsel, it's plea counsel, says he's had a horrible upbringing, but he's been going through these different programs like Turning Leaf and other things that are available in the jail. And those have been really helpful to him. We hope that you will impose, or at least allow for mental health treatment, because it seems to be helping with that. And that is something that the district court did allow. So that's, while I would acknowledge that that's not exactly an explicit on the record discussion of it, there is indication that there was consideration of it, perhaps is not completely explained as one might. So that would be my response to that. Now,
and I'll be candid. I think the facts of this case are pretty horrific for the defendant in terms of the conduct that he engaged in and pled guilty to. And it may very well be that Judge Norton might not be moved if asked to expressly consider sort of this background information. I'm just concerned about the fact that our cases suggest that there has to be some acknowledgement of the case, and it wasn't as clear to me as I would have liked.
And I appreciate that, Judge Diaz. I would say that.
Let me ask a question with respect to a point that Mr. Anderson raised. Mr. Anderson was saying that the district court did not resolve the question of whether KS was a minor or not. That was one of those things that was left unresolved. What is your response to Mr. Anderson's point?
Well, I would have to agree that there is no on the record discussion of that at either of the sentencings. Of course, in the first one, the objections were withdrawn.
If she's an adult, does the criminal history go down to 14? Go from 24 to 14?
Well,
it went from 24 to 14 on the basis that there were no minors involved. And then the judge said it went back to 24 because there were minors involved. But Mr. Anderson says whether KS was a minor was never resolved.
So to answer your question, Judge King, the 14 versus 24 issue, as the district judge explained in that second order from April 2018, I believe it's JA 98 and 99. It's a footnote that spans 2 pages. Says that's really immaterial because I'm finding that this cross-reference, which sets everyone's offense level at 30, is what drives the guidelines issue. Now,
it would seem to me that in imposing special condition number 7, which relates to no unsupervised conduct with children, that the district judge was pretty plainly saying this was a minor, because otherwise it would, the special condition would not be sufficiently tied to the characteristics of the offense. So I suppose that special condition resolves the question. But I guess the question is that as a general matter, there are a number of things that are implicit in what the district court said. I think it's implicit that he found that KS was a minor in terms of the trafficking, and it's really quite depressing what was done with this woman. It's a very, as Judge Diaz points out, the conduct here is really bleak. And so the question with both the unresolved bit about the being a minor and also about addressing the background here, it seems to me that you are right in saying that all of this was implicit. And the question I have for you is just being implicit enough, or do district judges have to be explicit and not just be implicit? Because the point I think that your opposing counsel is making is that there was some shorthand here, and things that should have been made explicit were only dealt with implicitly. And you don't want the sentencing here to be just an exercise in shorthand. But at the same time, it's the conduct here was absolutely horrendous, and I'm not sure that it is going to make a difference. My guess is if it's sent back for a fuller explanation, we'll get a fuller explanation. I would be surprised, in light of Judge Norton's comments, if there were any, if he did anything differently. But the question I think that is being raised is the value of having district judges being explicit rather than implicit, where you're talking about quite a bit of time. Even for someone who has committed a perfectly horrendous offense, in my judgment. But this is what I think we're getting at, is the obligation of district judges to be explicit on this stuff. And I want you to, why isn't that an important value in our system?
Oh, I wouldn't say
explicitness.
Oh, I don't disagree that it's an important value, Judge Wilkinson. And even if I had an idea to disagree with it, I certainly acknowledge this court's cases saying that explanation is required. I would say, as to the mitigation argument relating to the childhood, we cited cases like Bulware, Palacios, I believe, forgive me if I mispronounced that, and Crouch, which talk about family history, family upbringing, those difficulties not being addressed, but nevertheless harmless error. So,
are you arguing harmless error here?
Yes, sir.
Are you arguing like a clearly guilty rule? You ever heard of that one?
I'm clearly guilty of not being familiar with that rule.
At some point, that's what the harmless error thing can become.
Right.
Right? Clearly guilty rule.
Right.
He's a bad guy, and circumstances are terrible, and we all agree with that. The question is whether the proceedings here complied with the requirements that we've laid down.
Yes, sir. I understand. And I would say, again, as to this upbringing mitigation argument, we are arguing harmless error on that point.
You're arguing plain error on some of it. You're arguing plain error on the conditions, right?
Correct. I believe my friend and I agree on that it is.
You're saying none of that was preserved.
Well, I'm sorry. I should try and clarify on the substantive reasonableness of those conditions. I think we agree that it is plain error controlling those. And I'll be happy to get into those conditions at this point.
Well, I'm just talking about the standard of review.
Right.
You're arguing harmless error on some of it, and you're arguing plain error on some of it.
That's correct.
So
And the plain error
I'm
is
sorry.
plainly more to your advantage because the burden lies with the petitioner. It's a harmless error. The burden is obviously reversed. A lot of this difficult childhood, sometimes can become boilerplate, but I think Judge Diaz was suggesting here that this was something more than, when you look at the PSR, that this was something more than just boilerplate, that it was more extensive in detail than a lot of the things we usually see. What's your response to that?
I don't disagree that that Mr. Black's upbringing was something I would ever want for myself, and but in terms of it being more detailed than what I typically see in sentencing memos, I won't say it's the least detailed or the most. I think I've seen things that run the gamut in terms of detail or how bad they were. I'm certainly not saying that he had a perfect upbringing at all. No, we would never.
My question is simply this: that if something comes up, like, and we may not need to deal with it, but if something comes up here on plain error with respect to supervised release, and then it's sent back for a procedural reason, and it comes up, and I'm sure objections would be made in some form or another after the remand. So if we review another appeal here, are we still under plain error, or is that just completely wiped away and we were considering the objections independently of plain error review because after the remand, an objection was raised?
I think at that point, Your Honor, it would not be plain error if to any supervised release conditions that were specifically challenged below.
Okay. All right, thank you. Judge King, you have further questions you wish to ask?
I'm fine, Your Honor.
I don't either. Thank you.
Thank you, Your Honor.
All right, Mr. DeHall, we thank you very much, and Mr. Anderson has some rebuttal time.
Thank you, Judge. Briefly, I certainly would agree that certainly the facts that are alleged in the pre-sentence report are terrible. But I would note that one of the objections that Judge Norton didn't resolve, because one, it was withdrawn at the first hearing, but then revived at the second, but not actually addressed, is that Mr. Black's attorney objected to being involved in any conduct other than with KS. And so he got a 4-point enhancement on the guidelines for having multiple victims. And while certainly what happened to KS is terrible, Mr. Black would be in a better position for sentencing for 3553A if we were only talking about him and KS, not him and the other 4 victims that the PSR said that he was associated with. I would also note that Judge Norton didn't max him out on the guidelines. He gave him the midpoint of the guidelines. So it's not the type of thing where Judge Norton, thought that Mr. Black was completely irredeemable. So I would note that as well. In response to Judge Wilkinson's question, I would agree with Mr. DeHall that if the court vacates the sentence below, when we have a resentencing is a resentencing from start to finish. And so if, for example, the guidelines were to become more lenient because of something that the Sentencing Commission does, where you would use those new guidelines, Mr. Black's attorney would have the opportunity to make new objections. And I hope that with those objections, particularly to the supervised release conditions, that might prompt the judge to modify some of the language to say, well, for example, the one about computers, like that condition as it's written would prohibit Mr. Black from ever going to Pacer to pull up his case. And that's not really what we're talking about. What we're really talking about is he shouldn't be able to go to a place like Backpage. And so once Judge Norton is alerted to that, then I think that he might modify some of that language, and it would avoid some of the constitutional concerns that I've raised to give Judge Norton sort of a fair shake to have that presented to him. The other point that I was going to make is about the condition of a mental health that Judge Diaz brought up. Again, the Cromer case that the USA noted as supplemental authority, which is a published decision from this court, lists as the types of things that are not allowed include, quote, whether a defendant must attend a treatment program, close quote. And as I read condition 2, it is entirely up to the probation officer the day that Mr. Black gets out of prison, whether Mr. Black does or doesn't need to go to a mental health program. And that would be inconsistent with Cromer if the court views that condition as leaving it up to the probation officer to decide on day one, do you have to pay for him to go to treatment or not? And I think that language in the condition, as deemed necessary by the probation officer, means there is no default given to the probation office. And I think that to comply with Cromer and the other cases about a mental health treatment, the judge has to set the default. So I'm going to order you to go to mental health treatment until you are released from the probation office. But that's not what this condition says. It's as deemed necessary. And so I think it's entirely unclear as to whether, what is the base level here? Is it you have to go or you don't? And I would say that, the judge, particularly given that we're talking about a constitutional concern, Article 3, this is not some sort of abstract, a statutory problem. But I think that, this court has to be jealous in protecting the Constitution. And particularly when we get to things like delegation, I think that's an important value that we have in society. And so with that, if there are no further questions, I would just ask you to vacate and remand for a resentencing.
All right, thank you very much, Mr. Anderson. And Judge King, Judge Diaz, do either one of you have further questions of Mr. Anderson?
I do not, sir.
I don't either. Thank you.
All right. Thank you very much, Mr. Anderson. And thank you very much, Mr. DeHall. And we appreciate your being here. Mr. Anderson, I see that you are court appointed, and the court wishes to thank you for the fine job you've done on behalf of your client.
Thank you, Judge.
We wish you both a pleasant afternoon, and thank you for your good arguments. And with that, we will adjourn court and go into our conference.
This honorable court